Hello, welcome back to Legal Brain. In today's class, I'm going to discuss yet another important area and exam point of view, that is powers and functions of CCI, that is Competition Commission of India, based on Competition Act 2002. So first of all, what is CCI? CCI, Competition Commission of India, which is a watchdog of competition law in India. And this is established based on Section 7 of Competition Act, which is having a chairperson and 6 members and will be appointed by the central government. And the major duties of Competition Commission of India is to protect the interest of the consumers, to promote and sustain the competition in the market, to avoid discrimination or monopoly in the market, and to eliminate all the adverse effect on competition. So these are the major duties of a CCA. And in detail, by virtue of Section 7, we established this Competition Commission of India, and the commission shall be a body corporate by the name aforesaid, and it will be having perpetual succession, a common seal, which will be having the right to, hold or dispose the property, and so on. So, and the head office right now, it's in Delhi, and it will vary according to the decision and discretion of the government. And also, next one is Section 8, which speaks about composition of the commission. So, who are all are there in the commission? A commission includes a chairperson and 6 members. And if it is a minimum composition, it will be having a chairperson with 2 members. If it is a maximum composition, it will be having a chairperson with 6 members. So, this is the composition of the commission based on Section 8 of Competition Act. And the chairperson and every member shall be a person of a basic ability, integrity, standing, and who is having the knowledge and who having the professional experience in various fields, not less than 15 years. And they should be having an experience in international trade, commerce, economic, business, trade, law, finance, accountancy, management, industry, and so on. So all these areas, all these disciplines, they should have an experience not less than 15 years, and the chairperson and all the members shall be a whole-time members. And next is selection committee for chairperson and members of the commission. So this is based on Section 9. So by virtue of Section 9, the selection committee for chairperson has been constituted, and the chairperson and the members of the commission shall be appointed by the central government. As I have already told, they are appointed by the central government. And you can just look into the screen and try to understand. The chairperson should be the Chief Justice of India or his nominee. And we also have other members who should be a minimum of 2 or a maximum of 6. And this includes a secretary in the Ministry of Corporate Affairs, secretary in the Ministry of Law and Justice, and 2 experts of reputation who have special knowledge and experience, professional experience in international trade, as I've already discussed, international trade, commerce, industry, law, accountancy, management, and so on. So this is the qualification and the criteria in order to select. And next is the administrative powers of commission, the chairperson of the commission. And this is mentioned under Section 13 of Competition Act, and Section 13 says that the chairperson shall have the powers of a general superintendent and the direction and control in respect of all the administrative matters of the commission. The chairperson is the authority who is having the ultimate power to decide, to take decisions in the matters. And the term of office, Section 10 speaks about term of office. Terms of office of the chairperson and other members, which is actually 5 years. And also another point you have to note down is that provided that the chairperson or other members shall not hold the office of such after he has attained the age of 65 years. So it should be, he can hold the office for a term of 5 years, but he should not exceed the age of 65. And next is duties of Competition Commission of India. So these are the major duties under Section 18, by virtue of Section 18 of the Act that is provided. The first point is to eliminate practices having adverse effect on competition. So the major duty is to eliminate the practices that is causing an adverse effect on competition. For example, forming a cartel or causing an abuse of dominant position, or they are doing a price fixing, they are doing something illegal, or they are making an entry or exit barrier. So all these are the, all these will lead to an abuse of dominant position, and this will lead to a monopoly in the market. So in order to eliminate such practices that is causing an adverse effect on competition, we do have CCA. Second point is to promote and sustain the competition. So it is the main objective of Competition Act that we should promote the competition in the market, and there should not be monopoly. And based on Article 38 and 39, it is already stated that the wealth should not be concentrated in few hands, it should be distributed equally. And the third point is to protect the interest of the consumer. So a consumer is the, the ultimate, we have to take care of the consumers. So we have to make sure that they get the best product and the best price without any cheating or fraud or discrimination. So in order to protect the interest of the consumers, the CCA is taking actions, and the ultimate aim of the competition law and the competition commission is to protect the consumers from the abuse of the dominant position. The fourth point is to ensure freedom of trade. As I've already told you, our fundamental right in freedom of, trade and profession. So connected to that, we have to ensure the freedom of trade carried on by other participants in the market in India. So these are the major duties of the Competition Commission of India. Now, I'm going to discuss about the powers and functions. So, powers and functions of Competition Commission of India, which is mentioned in Chapter 4 of 2002 Competition Act. So, one by one, I'm going to discuss the powers. First one is Commission's power of inquiry into certain agreements and dominant position of enterprises. This is mentioned under Section 19. The Competition Commission of India can take an action, or they can actually inquire into a case based on three aspects. First one is based on a complaint or an information by the aggrieved party. Second one is on reference by the government or authority, like the government or the authority referred them and they are taking an action. Third one is suo moto. Suo moto means by like their own action, they themselves can initiate, steps and they can inquest. These three are the, the possible ways in which a commission can start the investigation. And also the commission shall, while inquiring whether the enterprise enjoys a dominant position or not, based on Section 4. So abuse of dominant position. The commission will take care whether there is any abuse of dominant position or not. Now I'm going to discuss the next set of powers. First one is commission's power of inquiry into combinations, which is mentioned under Section 20. So combination, which includes acquisitions, mergers, and which also include mergers, acquisitions, and so on. So while doing an acquisition or while doing a merger, we have to take care of certain things. So the commission may, upon its own knowledge or information relating to acquisition, which is referred under Section 5, subclause A, or the acquisition of control referred to Section 5, subclause B, or mergers or amalgamation, whatever be that, which is mentioned under Section 5, subclause C. So all these sections we have to keep it in mind based on Section 5. Section 5 speaks about combination. Section 5, subclause A, B, C. So based on this, if they are doing an amalgamation, mergers, or an acquisition, then the commission has to take care that the commission is having a power to do an inquiry to make sure that the combination is not discriminative in nature and there is no adverse effect on combination. So the commission shall, on receipt of the notice based on Section 6, subclause 2. Section 6 speaks about the regulation of combination. So based on Section 6, subclause 2, commission is having a power to inquire whether a combination referred to that, in that notice or reference has caused or likely to cause any appreciable adverse effect on the competition. So for the purpose of determining whether a commission would have the, effect or is likely to have an appreciable adverse effect on competition in the relevant market, the commission shall have due regard to all, and commission can take care of certain things. Commission can look into certain things like whether there is any entry or exit barriers in the market, the level of combination in the market is fair or not, the degree of contravening, powers in the market. It can also take care of the extent of effective, competition likely to happen in the market, and so on. So there are like various conditions when it comes to combination. So the cut short point is that based on Section 20, the commission is having a power to inquire into combination, and combination is defined under Section 5, and the regulatory mechanisms is mentioned under Section 6. The next power is power to give opinion on reference by authorities, that is mentioned under Section 21. So based on Section 21, where in the course of proceeding before any statutory authority, an issue is raised by, suppose an issue is raised by any party, that any decision which such statutory authority have taken, or if they are likely to propose to take, as would be contrary to any provision of the act, thing like that, which is there is a contravention to any provision in the act, then such statutory authority may make a reference in such a respect of such issue to the commission, and the commission is having a power, and the statutory authority may suo motu also make such a reference to the commission, and on receipt of such reference, the commission shall give their opinion within 60 days of receipt of such reference. So this is the power of the commission based on section 21. Next is power of commission to make references to statutory authority based on section 21A, which is, an amended provision. And it is stated that, where in the course of a proceeding before the commission, an issue is being raised by any party, that decision which the commission has taken during such proceeding or, proposes to take overall is contrary to any provisions of the act. That is the situation. On receipt of such references, the statutory authority shall give its opinion within 60 days on receipt of such references. And the next point is meeting of the commission. That is based on section 22. So based on the intervals, based on the commission shall meet at such intervals, they can meet in different places. They can set a committee and they can meet, and shall observe such rules and procedures in order to the transition of the business in the meetings, and they can discuss about the regulations, and the chairperson for any reason is unable to attend any meeting, thinks of the chairperson was unable to attend any meeting, then the senior most member present at the meeting shall preside the meeting, and all the questions that is put before this particular members shall be decided by the majority of the members present and voting. So provided that the quorum of such meeting should be of minimum of 3 members. So this is based on the meeting. The next point is power of commission to conduct inquiry under section 19. The committee is having the commission, CCI, the Competition Commission of India, is having a power to conduct inquiry under section 19. So if the commission is of the opinion that there exists a prima facie case, the first instant there is a case, and shall direct they shall direct this particular prima facie case to the Director General (DG) to cause an investigation. So Director General can do an investigation, and then if there is any new information, they found any new information, the new information may be clubbed with the previous information. So where on receipt of the reference from the central government or state government or any other statutory authority or information received under section 90, the commission is of the opinion that there is no prima facie case. If the commission found that there is no prima facie case, it shall close the matter. So I will just, I can cut short it into like little more simpler. The first one is that if the commission is of the opinion that there exists a prima facie case, it shall direct this particular case to DG, Director General, for an investigation. Suppose the commission is of the opinion that there exists no prima facie case, then they shall close the matter. The second condition. Third one is that the Director General shall, on receipt of the direction, submit a report on his findings. The Director General is supposed to give a report to the Commission, and the Commission may or shall forward a copy of such report referred to the parties concerned. The Commission will send a copy to the parties. And if the report of the Director General recommends that there is no contravention of the provision of this Competition Act, then the Commission shall invite objections or suggestions from the parties, because the notice is already been sent to the parties. And after that, if after consideration of the objections or suggestion, if any, the commission agrees with the recommendation of the Director General, it shall close such matters. So this is the the criteria falling under the power of inquiry. Next is power of commission to issue orders after inquiry into agreements or abuse of dominant position. So based on section 27, commission is having absolute powers to issue orders, necessary. The eighth power is power of commission to divide the enterprise enjoying dominant position. So by virtue of section 28, if commission found out that there is an abuse of dominant position or an adversible, AAEC, adverse effect on competition in the market, the commission is having adequate power to divide such enterprises enjoying such dominant position in the market. Ninth point is power of commission to conduct investigation of combination by virtue of 29. So we have already discussed about combination, and the commission found out that there is a, uh, malpractice, if there is a discrimination, then the commission can issue a notice to shockers to the parties to combination, calling upon the response within 30 days. And the report from Director General will also be sought to investigate. And the commission, if it is necessary, within 7 working days from the date of receipt of response of the parties to the combination, direct the parties to the said combination to publish details of the combination within 10 working days. And the next point is the power of the commission to issue orders of certain combination. The commission is having powers to issue orders if necessary. Then 11th point is extraterritorial power of commission. So this is an important area, section 22, 32, which speaks about extra territorial powers of the commission. And extraterritorial powers of the commission, which includes an agreement referred to section 3, that is anti-competitive agreement, which is entered into outside India. Suppose, which is entered into outside India, or any party to such an agreement is outside India, or a combination has been take place outside India. So these are the things that is happening outside India. If it is a situation, the Competition Commission of India is having an authority to pass such orders as it deemed fit. And the 12th power is power of commission to issue interim orders based on section 33. So by virtue of section 33, commission is having a power to issue interim orders if necessary. And they can also temporarily restrain any party from carrying on any business in the market. Then, other than that, the 13th power is appearance before commission, that is section 35. That is, a person or an enterprise or a director general may either appear in person, or they can authorize someone, or they can, one or more chartered accountants or company secretaries or cost accountants, they can appear, or even legal practitioners or any of his or his office to present, to represent before the commission. 14th point is power of commission to regulate its own procedures. They are having a power of its own. Mainly based on section 36 sub clause 1, that is natural justice. You have already heard about odi altrum partem, that is here the other side. So both the parties should be present and both the sides will be heard. And the 15th point is power of civil court. The commission is having a power of civil court, and they have the power to issue orders, pass decrees, and which mainly include some summoning or enforcing attendance of the person, examining him on oath, requiring discovery, production of documents, then receiving evidence on affidavit. They have all the powers which is mentioned under the Indian Evidence Act 1872 based on sections 123 and 124. And next one is power to call expert. If there is any, if they need any clarification, or if they need, the examination of an expert, they have the power based on section 36 sub clause 3 to call upon any expert in the field of commerce, economics, accountancy, international trade, as I've already mentioned, from this kind of trades. 17th power is power to call for document or information. So they have the ultimate power, and they can direct any person to produce before the Director General or the Secretary or any officer authorized by it to produce the relevant documents, books, and so on. So to provide such information. Next is power to rectify orders. So they themselves have a power to rectify orders based on section 38. And they themselves can rectify their own notion. And also it is like an amendment can be made to any subsection of its own motion, or an amendment for rectifying such mistake which has been brought into notice by any party. So they have power for that. And 19th power is execution of orders of commission imposing monetary penalty. So monetary means, they can impose penalty, money penalty based on section 39. So for this, if a person fails to pay any monetary penalty imposed on him under the Act, the Commission shall proceed to recover such penalty in such manner as may be prescribed by the regulation. So in case where the Commission is of the opinion that it would be like expedient to recover penalty imposed under the Act, they can seek the help of provisions of Income Tax Act and Income Tax Act of 1961. and they can actually initiate the proceedings to get the penalty amount. So these are the major different types of powers of Competition Commission of India. So I have tried to sum up all the powers in one single class. I hope it's clear for you. If you have any doubt, do comment below. Thank you.